I'm really excited to introduce to you this evening's panelists. We have Elena D'Agostino. She is a public defender of Solano County, and Mr. Phil Telfeyen, who is the executive director of the Equal Justice Under Law. So just to give you a little bit of detail about Ms. D'Agostino, she became the Solano County's public health defender in 2019. She's been the deputy public defender since 1998 and was promoted to chief deputy public defender in 2010, and then to the interim in 2019. During her tenure, she has supervised both felony and misdemeanor attorneys and represented clients in dozens of jury trials for all types of crimes. Ms. D'Agostino obtained her JD from Fordham University School of Law in New York. As a law student, she interned with the Legal Aid Society Criminal Defense Division in Manhattan. Mr. Telfeyen, who is joining us from Washington, D.C., worked at the Harvard Law Review, clerked at U.S. Court of Appeals in Washington, D.C. as a trial attorney at the DOJ Civil Rights Department before founding his organization, Equal Justice Under Law, in 2014, with the goal of ending inequality in our justice system. Phil has helped to build the center into an aggressive agent of legal reform, fighting to end America's money bail system, pushing for an end to the war on drugs, striving to limit excessive collateral consequences of criminal convictions, and advocating on behalf of those experiencing poverty.
Well, thank you so much, Professor Kelly, and so nice to meet all of you. Greetings from Washington, D.C., greetings from Equal Justice Under Law. As Professor Kelly explained, I'm the executive director of the nonprofit Equal Justice Under Law. And the way Public Defender D'Agostino and I discussed, I'll try to talk for about 20 minutes about some of the work that we do. She'll talk for about 20 minutes about the great work from her office. And then we'd love to save another about 20 minutes for questions from you all. So I'm not going to use the chat function while I'm talking. I'll just try to give an overview. And then maybe we can do a live Q&A at the end, or use the chat function at the end. But that's to say, maybe save questions for the end as they come up, just to make it a little easier on us. So I'm one of those lawyers for whom 20 minutes is like a vanishingly short amount of time for all the stuff I want to talk about. So I will try to move quickly, but try not to talk too fast. And I saw some of the readings that Professor Kelly had circulated in advance. I think you all are getting a taste of the work that I've been doing at Equal Justice Under Law now for 8 years. I've been a lawyer for 13 years. As Professor Kelly said, I was in the Civil Rights Division of the U.S. Department of Justice first, and then started this nonprofit. Our goal is to end wealth-based discrimination in the criminal justice system. Like a lot of you, when I started this nonprofit 8 years ago, like a lot of you, I didn't realize how pervasive this issue was. So I'm going to try to highlight a handful of the examples of the cases that we work on, just to give you all a taste of what we've seen, and there's more out there. So in my mind, the first thing that comes up is sort of the most overt example of wealth-based discrimination, or the criminalization of poverty. And someone, I think it was Kiefer, had put in the chat earlier about spending a night in jail for being unable to pay a speeding ticket. That's the first area we worked on as an organization, still working on, which we call debtors' prisons. Effectively, in a lot of places throughout the country, if you owe money to the government and you can't afford to pay it, a lot of counties will put you in jail, even if whatever you did is not a jailable offense. So like an example in the chat was, for a speeding ticket, you usually don't go to jail for getting a speeding ticket, you just get a fine. But in a lot of places, if you can't afford to pay that fine, you'll go to jail. What's so bizarre about this practice, there's two things. One, it's commonplace. It happens all over the country. We've had cases tackling this issue in California, where you all are, in the South, the Southeast, the United States, Northeast, in the North, in the Midwest. Every state has counties that do this. It's usually on a county by county basis. So it's surprising how pervasive it is. But the second feature that makes it so surprising to me is it's established to be illegal. The Supreme Court has spoken on this very issue many times, telling governments you can't jail someone just because they're unable to pay a court debt. that is a well-established principle of law that it's not a close call. It's not a hard question. And the U.S. Supreme Court, which sets the law for the whole country, has clarified the issue. So when we file these lawsuits against what we call debtors' prisons, it's easy legally. What's hard about it is proving it, because counties will argue any number of bases for why people are in jail. But at the end of the day, the rule is you can't put someone in jail just because they're too poor to pay a court debt. And so that's been a lot of our work. We've actually just filed a case that's totally unique. Typically, what we see is people being jailed for not paying court debt. So something like a speeding ticket, or any sort of municipal infraction. There's all these code regulations, for example, about one of our clients had the trash bin overflowing, and there was literally like a $25 citation that she couldn't afford to pay. So she went to jail for that, which is, again, illegal, but that's how the county was handling it. So there's a lot of what we call like fines and fees, people being jailed for unpaid fines and fees. Another area where we see debtors' prisons is for court-ordered child support. It's amazing how pervasive this is. Parents separate, and courts often order child support. For a lot of our clients, what we've seen is those orders go in without the parent even knowing, because they didn't know there was a hearing, they didn't show up. The court orders a huge amount of child support, and one of our clients is unable to pay it. Maybe they lose their job. Maybe they weren't working to begin with, but the court ordered a very high amount. People have gone to jail for unpaid child support. But the most bizarre reason that we're just talking right now is in Arkansas, the only state in the country that has this rule. If you can't afford to pay your rent on your apartment, you can go to jail for that. In Arkansas only. Everywhere else, I assume everyone here, lives in California. Everywhere else, including where I live in Washington, D.C., if you miss rent, your landlord files a civil lawsuit, an eviction lawsuit in civil court, and you have the right to defend yourself. So they have to set a hearing, and you show up for that hearing. You argue either that you did pay, or the landlord's not providing heat, so I had to provide my own heaters, and that's it was been uninhabitable basically. You have defenses. Well, in Arkansas, if you miss your rent, regardless of the reason, the landlord can call the sheriff and say, hey, Phil missed his rent, come arrest him, which actually happens. So we just filed this lawsuit a couple of months ago. It's the only state in the country that makes it a crime not to pay rent. It's so egregious to me because it's a private arrangement, it's a private contract, right? But this couple that we are representing, the Easleys, both in their 60s, they're not working. They both have physical disabilities that prevent them from working, so their only income is disability payments. Well, they were paying their rent just fine for many years. The landlord wanted to do some repairs on the water heater. And I don't know all the details about what happened, but basically whoever came in to fix this water heater maybe wasn't well trained, busted some pipes. There's no running water in the Easley's apartment right now. And it's been that way for almost a year. Not no hot water, no running water at all. No running water. So the landlord said, I'm really sorry, we damaged the pipes. There's no more running water. I'm going to give you 1 month free rent. Okay, so they didn't pay rent for 1 month, but in month 2, the landlord said, now it's time to pay again. Now, the Easleys, again, this older couple, they don't work. They're just getting disability payments. If you can imagine living in a place with no running water, what were they doing? I mean, they were buying jugs of water. They were buying bottled water, both for drinking, for washing their hands, for bathing, for cooking, for any purpose. All that water had to be acquired at some expense, buying big tubs, using gas to get to, some public fountain, or buying bottled water. They also had to rent a porta potty or porta john, whatever you call those things. They have in their front yard a little plastic house where they use the bathroom. The toilets don't flush. So they're paying all this extra money. They're very, very poor to begin with, so they don't have a lot of money. So they haven't been able to pay rent because of the landlord's fault. And so after about 9 months, the landlord called the sheriff and had them arrested, which to me is just such an insane scenario, because again, in any other city, in any other state, that landlord has to go to court, and any judge is going to say, wait, you've not been providing them water? No, you can't expect people to pay rent if there's no running water. But in Arkansas, it's a crime. So we're suing the state of Arkansas for this unjust law, and it's yet another example of what we would call a debtor's prison. It's sort of a direct, explicit criminalization of poverty. So I spent a few more minutes talking about that one issue because it sort of is emblematic of all of our work. It's sort of the theme of our work is this criminalization of poverty. Another area that we've worked a lot on, that some of your readings touched on, is money bail, which I think of as a very similar concept. It's essentially a price tag on freedom. You get arrested, the sheriff drives you to the county jail, puts you in jail, and says, pay $10,000 for your release, or pay $50,000 for your release. Or like one of our clients who got in a fist fight with her brother, $150,000 for her release. The guy didn't die or anything, they just had a family brawl. Not to say that that's okay, but it wasn't what I would call the most serious, public safety threat at all. $150,000 bail. So it's a price tag on freedom. If you have the $150,000, you can get out, and actually it comes back to you. Bail is sort of like collateral. If you show up for court, it comes back to you. Or in a lot of cases, people will use a private bail company and they'll pay 10% non-refundable, but they'll post $15,000 to the bail company. That never comes back to them, but they've still essentially purchased their way out of jail. For clients like ours, all of whom are indigent, they can't afford the $150,000 or the $15,000, so they end up sitting in jail until their case goes to trial. That makes it harder to take care of dependents. A lot of our clients have, children or parents that they're taking care of in either direction. It makes it hard to maintain employment. Most of our clients will get fired after one day of missed work. When you think about low-wage jobs, they tend to be pretty unsympathetic to someone missing work even once. Here at Equal Just Under Law, we're a nonprofit. It's a bunch of lawyers here. If someone misses a day or two of work, they're not going to get fired. I'll call and check in and say, hey, how come you're not at work? But there's a little more grace. But if you are, flipping burgers is the classic example. You miss work. If you don't, because you're in jail, you're probably getting fired the next day, right? So it's just totally disruptive to life, all because someone can't afford to purchase their freedom. So we think of money bail as a very similar example of criminalization of poverty. States think of all sorts of creative ways to punish people for being poor. Another example that we work on is driver's license suspensions. California just last year passed some legislation to reverse this, but in most other states, in 42 states across the country, if you have unpaid court debt, the state will suspend your driver's license. So I already talked about being thrown in jail for unpaid court debt. It's a similar thing. And in a lot of ways, for a lot of people, that can be even worse. Think about how many of you use a car to do anything, to drive to work, to drive to school. Obviously, it's a little different with this whole virtual classroom stuff. But for most people, the car is an absolute necessity of life because they need it to get to work. And that's what's so perverse about this penalty is the state says, oh, you never paid your $100 fine for littering. We're going to take away your driver's license. And then most of our clients say, well, now I've lost my job. How am I ever going to pay that $100 fine because I can't drive anymore? Or in the child support context, we see the same penalty. Someone couldn't pay their $300 for 1 month of child support. And so the government says, well, we'll suspend your driver's license. The person says, great, I just lost my job. I can't see my kid anymore, right? So I'm not as good of a parent. And I can't pay the child support that I'd like to pay, right? But I just can't. All this stems from the government's assumption that everybody can afford to pay, and they're just choosing not to, which is, of course, a faulty assumption. We can speculate as to why that is. Part of it, in my mind, is that most government officials, state legislators, even city councilors, tend to be wealthy folks. They tend to be well-connected. They tend to be professionals. They tend to be high-income earners, in part because it costs a lot of money to run for public office, right? Running all the ads and stuff. It's, frankly, rich people, excuse my French to use that term, but, it's people who can afford it. And so they're legislating as if all the citizenry can afford the $100 ticket. A lot of people can't. There was a study in Orlando recently, I'm sure a lot of other cities, that showed that 80% of people living in Orlando could not come up with $500 within a 24-hour period if their life depended on it. Meaning they don't have $500 in savings. They don't have friends or relatives who can loan them $500. It's just not there. right? And so when someone gets $100 speeding ticket or $100 ticket for littering and can't afford to pay it, it really illustrates when you are living paycheck to paycheck, what that literally means is every dollar, every cent is going to basic necessities like rent and food and clothing and medication. And you're not putting any money in savings, and there is no savings account. So the driver's license suspension is another big area of what we would call the criminalization of poverty. There are a few other areas I want to touch on before I want to pass it over to Public Defender D'Agostino that are more in the nature of financial barriers to the access to justice. So a lot of our work in wealth-based discrimination justice system talks about access. So in one area, the U.S. Supreme Court has talked about this issue, and that has to do with divorce. If any of you are married and are thinking, oh man, I want to get a divorce, but I just can't afford it, the U.S. Supreme Court said about 40 years ago, the state has an obligation to waive the filing fees for divorce. Everybody should have equal access to that system. You shouldn't, and most states do have a filing fee, but if you can't afford to pay it, it has to be waived. That principle has not been extended to a lot of other important areas, and I'll talk about a few of them. One is expungements. In every single state, there is some process for getting old minor records expunged. Usually states are very, very restrictive. It's often only misdemeanors and sometimes nonviolent felonies. So it's, minor offenses, and they often have to be 5, 10, 15, or 20 years old even to be eligible for expungement. So it tends not to be, any old thing, but just, a small subset of minor offenses if enough time has passed. So, but many of those states will charge fees to get those records expunged. An example is a case we're working on in Louisiana. In Louisiana, it costs $550 to expunge any record event, whether it's an arrest or a conviction. $550 to expunge, and it's per event. So you're filling out one form. We've done this with our clients. One of our clients has 2 arrests and 2 convictions. Quick math, multiply by 4. That person has to pay $2,200 to expunge 2 arrests and 2 convictions, all of which are for misdemeanors, all of which are over 17 years old. The law in Louisiana is 10 years, but they're just very old for him because he's lived a clean life since then, right? So he's got these 17, 18, 19-year-old offenses basically from when he was a teenager, right? Now he's trying to get jobs. And a lot of employers are running criminal background checks, especially at low-income jobs. Again, another example. We're a civil rights legal organization. I don't run background checks when we get an application from an attorney, but low-wage employers tend to do that. And they tend to discriminate if they see any conviction, even if it's old, even if it's completely unrelated to the job. So this expungement is really important, but there's a fee standing in the way. So we think of that similar to divorce. We're trying to make that same argument for us. Like, look, the state has to waive the fees for divorce. They should have to waive the fees for expungement. But they're not doing it in Louisiana and so many other states. Another sort of access to justice issue that we're working on has to do with voting rights. We're all conscious of the importance of people's access to voting, and almost every state allows people to vote after they've finished serving a prison sentence. If someone's convicted for a crime, in most places, I think there's 1 or 2 exceptions. I actually think Oregon might be one of them, nearby to California. But in almost every state, when you're convicted of a felony, you can't vote while you're in prison. But in almost every state, once you get out of prison, you can vote again. You've repaid your debt to society, you've served your time, and they say you're eligible to vote. In a handful of states, about 12 of them, once you finish serving your prison time, you're eligible to vote, but you have to pay a fee to get that right to vote back. Now, some of you may know, and especially some of the readings, someone walking out of prison is often the least likely able to pay fees. They don't have an extra $500 lying around to pay filing fees. Also, it's just very hard to reintegrate into society. That person doesn't have an apartment. That person doesn't have a job, right? They were just in prison for a couple of years. For a lot of folks, their relationships have deteriorated. It's hard for family members. Our clients, a lot of my clients have told me in those first few months, my brother was coming almost every day. My mom was there. 6 months later, 12 months later, I wasn't seeing people. People weren't visiting as much. Those relationships deteriorate. even with family, let alone friends who you don't hear from ever again, right? So you see the social relationship deteriorating, you see housing and employment destabilizing. These folks don't have money, and a lot of states will say you can't vote again unless you can pay for it. So that has to do with sort of access to justice. And then the final area I want to talk about, which to me is the most egregious example of wealth-based discrimination, is a relatively new area we've just been getting into in the past couple of years, because I think it's just starting the past couple of years, is more and more states and counties are charging people for pretrial supervision. And I want to emphasize pretrial. People are being arrested, haven't gone to trial, haven't been convicted, and the state says you have to pay upwards of $350, $400 a month for your supervision. If you can't pay it, you go to jail. What's so crazy to me about this is you haven't been convicted of any crime. It's effectively like being fined prior to conviction. One of our clients had to pay over $6,000 in pretrial supervision fees. Otherwise, she would have gone to jail. And then she was never convicted. The state, after about a year, eventually dropped the charges. All that money's gone. She doesn't get it back. So we're seeing more and more places charging pretrial supervision fees. And it's consistent with this monetization of the criminal justice system, where where governments are trying to squeeze money out of people to fund the system, and typically preying on people without money. So I've already gone over my 20 minutes. I want to pass it over to Public Defender D'Agostino. And I should highlight, before I do that, our work is on the civil side. We're suing governments to try to get them to change the laws. What Public Defender D'Agostino's office does is really what I call God's work, representing all the people who are being abused by the system on the criminal side of things. So she'll talk more about that. And I'll save time for questions in about 20 minutes when she's done. Thank you all.